during that time, did you guys have any information that he had gone back to the car when you're talking to the defendant as opposed to Mr. Milling?
No.
But luckily, who was it that had gone back and reviewed videotapes and saw this happen, looking at badge access, were wise enough to go back and look at this?
I did.
Did Home Depot actually pull that video too?
They did.
Now, we saw that the receipt that was crumpled up and thrown away, the Publix receipt, which has been introduced. In that video, did the defendant actually open up and look at the receipt and see which exact receipt it was at that time?
No.
He just looks down, sees the receipt, and tosses it.
Correct.
You were asking questions about the vacation, Googles, and things of that nature. Just wanted to clear up some timing on that. Let me get back and ask. I believe it's 6:07, Brian. Thank you. Looking at the timing of these texts, she's the one who first texted him, correct, on June 17th at 10:19 a.m.?
Correct.
Okay. And he texts her back at 3:16 p.m. on that same day, correct?
Correct.
And so the email, though, that he sent to the travel agent wasn't until 2 minutes after that, correct? So when he told her he was just waiting to hear back from the agent, that wasn't true, was it? While we're talking about vacations, did you also uncover any other Google searches about vacations or going to far-off places on his computer?
We did.
Okay, on the Lenovo, did you, on June 13th, find anything, Google searches about remote islands to move to?
Yes.
Do you remember the names of those islands by chance?
We do know.
Okay. Also, June 17th, the day before Cooper's death, were there also searches for other islands like Antigua and Sandals, places where children can't go?
Correct.
And the defense asked you several questions about, well, did you make a report about this email from Ms. Coyle? Was that any evidence that you actually sought out and obtained?
Yes.
Okay. That both parties have?
Yes.
Did you have any evidence that he ever responded to that email or called her, anything of that nature to follow up with?
No.
Okay. He also asked about any information child-free, if you follow up, put that in your report. Is that all information that was provided to the state and then to the defense?
It was.
Now, after that July 3rd probable cause hearing, which was about 2.5 weeks after the arrest, was there a ton of evidence that you basically recovered and turned over that was a specific supplemental was not done?
Correct.
And did that only pertain to things that the defense is saying or that they want to introduce?
Judge, that's leading.
It's a yes or no answer. It's not. I'll rephrase it, Judge. Okay, thank you. Were there lots of stuff that that you uncovered from, say, Whisper app about all of these conversations, his double life, all these other things that came out? Did you do supplementals?
He's just testifying.
I'm pointing his.
It's difficult to make a ruling until I hear an entire question. He was in the midst of one. Finish.
Thank you. All of these things you found from the Whisper posts and things like that, did you do supplementals on those things as well?
Not all.
Okay. Did you do any supplementals about his statement saying he leads a double life?
No.
Okay, going back to the parking lot videos, the think defense counsel asked if he could have backed into the wood line and things like that. Now, those trees back there, those trees much bigger than the ones right beside where the defendant parked.
True,
And is it fully wooded back there?
true.
Okay. In the vet video, does he actually say, that veterinarian, and do you see video of trees waving in the background?
Correct.
And he says, windows down and still be hot enough to kill.
True.
You were asked several questions about people walking by the car. Now, some of these people, I'm sure the jury saw this, they were on the other side of the roadway from the defendant's car, correct?
Correct.
They weren't walking right by it?
Correct.
Okay. The defendant's back and rear passenger and driver's side door or windows, are those all tinted to a degree much more than the front windshield and the driver's side window?
That's correct.
And these people that were walking by the car, did that car belong to them?
No,
Did Cooper Harris belong to them?
no,
Did they go back at lunch and open up the door when they walked by?
no,
Did they spend over 30 seconds in that car with that child that morning before
No.
closing the door on them?
no.
Let's talk about that June 3rd, 2014 video. The defense played in here with the defendant when he parks messing around inside of that car. You remember that video?
Yes,
Getting his stuff out.
correct.
When you see that video, is he turning and leaning right over where that child would have been if the child was in the car that day?
Correct.
Defense asked you some questions about the child, about Cooper falling asleep on some videos and things like that.
Correct.
Okay, were these times all before 8:45 or after?
After.
Are you
Oh,
sure?
no, I'm sorry. The times where the child was sleeping is usually before 8:45.
Were those before he came in and had breakfast at Little Lake Park?
Yes,
Was there any evidence, like on the day of June 18th, that the child had slept in later?
yes,
Now, you spoke with the employees at Chick-fil-A, and they told you how he would act when he came in from Chick-fil-A.
I will object to hearsay.
Sustained.
Did you speak with those people? I'm not asking what they said. Did you speak with them about that issue?
yes.
Okay. Talking about things on the computer as well, and the effects of objects in a car, I'm going to show you what I'm marking for identification purposes as States Exhibit 651. Detective, showing you State's Exhibit 651. Do you recognize that?
I do.
How do you recognize that?
This imager or photo that came from his computer?
And did you uncover this imager? Did it have a title that was on his computer from June the 6th of 2014?
Yes.
Okay. And what was the title of the actual post?
So just to summarize, it says, I guess it did get hot in the car today, or it did get hot today.
Your Honor, I tender State's Exhibit 651.
Just the same objections that we previously made regarding using electronic evidence.
Admitted over objection.
Basically, melted gums.
Yes, sir.
You were asked several questions about testimony given at the probable cause hearing July 3rd, 2014. And again, that was just a little over 2 weeks after arrest.
Yes.
At that point, was he under the arrest for intentionally killing his child? Was he under arrest for that? Had he taken out any warrants for
No.
malice, murder, or anything?
We had not.
Were you still investigating it?
We were.
He was, basically, that was subject to a warrant for negligent homicide, correct?
Correct.
All right. Usually, as you told the defendant, how long is a probable cause hearing before there is a hearing?
30 days.
Did you ask to move this up?
I did not.
Was this something that by July 3rd that you guys had already gotten everything together, had your whole case file, had finished your investigation? Or is this something that y'all were just in, I guess the investigation was in its infancy?
It's still in its infancy.
Okay. Now I'm going to go back regarding that. The defense asked you some questions from a transcript involving the PC hearing regarding the how hot does it get in a parked car video. I'm going to go back over that a little bit just to make sure we have the full context of everything. Just give me a second, Judge. Okay. And at that probable cause hearing on page 59, you had actually discussed the defendant telling you he had looked at some video on the internet. Okay? And to be fair, looking at page 60, and perhaps inartfully, was it me who actually used the term, did you find a web search on his computer, the Lenovo, related to what you described?
That's correct.
Okay. And did I ask you if you actually found the video on his computer?
Yes,
And then you went on to describe what the video was?
that's correct.
Okay. Now, looking at it further,
I'm going to object. He's got the transcript in front of him, and he's misquoting what was actually said on page 60.
did you find the web search?
Object to the form of the question as it was asked.
I'll get him to read it again. When I asked you that question, what did I ask you?
Did you find a web search on his work computer, the Lenovo, related to what he had described to you?
Okay. And what did you say?
I did.
And then what did you say?
Did you actually find the video on there that he described to you?
And then what did you say?
I did.
Okay. So that was actually me using the term web search. Okay. Now, did you testify later about this as well?
I did.
So in this same hearing, you gave further testimony about this issue. Let me ask you this. Did you ever say that the defendant got on there and there was evidence that he Googled hot car searches, death, anything like that?
No.
Okay. If anybody said that, that would be untrue, correct?
Correct.
Also, Mr. Kilgore actually said, used the term viewed entire video twice. Did you ever say or testify that the defendant had viewed the entire video twice?
No.
It's nowhere in this transcript, is it?
No.
What page you want, Joe?
That's the entirety of the transcript. It's not in there. Now going to page 101, we're being asked questions by the defense counsel about the video. Okay? Now let's read into context everything that you testified about on the same day about this situation. Starting, Mr. Kilgore asked you, the video, you said that was from you said yes, sir, and then he said, that posted up on Reddit on June 13th. He asked you that question.
Correct.
What did you say about where it was posted up or how he came to find it?
I don't know when. Well, he read it. I'm sorry. I don't know when it was posted, but he accessed it on June the 13th, 2014.
And then he asked you, oh, and it's fair to say that you know with all certainty that's not something he Googled or searched out. It was simply a story that was a video that was posted up on that site, correct?
Correct.
And then what was your answer?
No, I can't say that.
At that point, had you determined exactly how he had gone to it and found that video and seen it and viewed it? Okay. He also asked you another question, but that's the site he saw it from, Reddit. And what was your answer?
No, I'm not sure if it was Reddit or YouTube.
Okay. And then he asked you, because the video was actually shared on YouTube and on Facebook and several other places, right?
Yes.
And what was your answer?
Yes. When I watched it on YouTube.
Okay. And then he asked you, you said that you were able to tell that he watched it twice.
Yes,
And you
sir.
said, yes, sir. And then what did you go on and how did you describe it? What was your answers?
I don't have the times. I know the date of the first one, June 13th. I don't know the date of the second one yet.
And then did he actually ask you, could it have been the same day? What did you say?
Possibly.
Did he ask you, could it have been that he got called away from his desk at work and it came back and hit resume to play the balance of it? What did you say?
I don't know.
Then he asked you, but it could be.
I would not say that.
Because at that time, did you know for sure the intricacies of where that video came from and how he viewed it?
No.
But you had no doubt that he viewed it, correct?
Correct.
Okay, and this link was on, he's on Reddit. He sees a link, how hot does it get in a parked car, and clicks on it. Is he taking an action to view something he sees and wants to view?
That's correct.
And from what he told you he watched on it, did he learn information about it?
That would call for speculation.
I believe that's a fair question based on what he told him and then viewing it, if he learned information from the video.
Allow.
Did he learn information from the video?
Yes.
About temperatures rising, things like that. Even if windows are cracked, you can still kill.
That's correct.
And he told you this. And in common sense, in a general sense, would you call that research?
Yes.
And who is the person that tied this video to Cooper Harris in his own words?
The defendant.
Also, when he talked about that advocate, who he said had caused the death of his child and then comes out and advocates on this whatever show that he had watched, and did you know for sure whether he watched it on the internet, TV, or which one he'd watched it on?
No.
Who did he equate that person, that advocate to?
Himself.
And so again, from that, did he tell you that he had learned information from this show?
Correct.
We talked a little bit about child free. I'm not going to belabor this. This was, you testified on July 3rd, a couple of weeks after the death of Cooper, correct?
Correct.
Okay, as a detective who is responsible for investigating the death of a child, whether negligence, intentional, the fact that he has clicked in and typed in the website child free, are you going to address that and look into it?
I am.
And I realize this was April 28th, and a friend told him of its existence, correct?
Correct.
And he told him it was the atheism of children or something like that?
Correct.
Being told that, he still went to this page.
Correct.
Okay. And the main page, while these articles are kind of here and there, the main page, the child free, there's no doubt that that page espouses living child free, correct?
Correct.
And it's still on the same day, but even after he said grossness, did he keep on reading other articles from the same page?
He did.
And these Google chats, now these Google chats that, did those come in with emails and things like that from his main Google account?
Yes.
And were there pages and pages of records and things like that?
There were.
Were these all things that you turned over to the state and were turned over to the defense?
Correct.
All right, the parking lot video that we saw as far as the defendant at lunch. I know, just to clear up one thing, defense counsel kept talking about having to do a 180 to turn around to look at something behind you. And when he was doing that, which side was the defense turning his head?
The left.
Is that accurate to the way he would have been turning, looking back to somebody to his right?
No.
He would have been doing this, right?
That is correct.
So the defense was turning the wrong way.
Correct.
Did you ever see any evidence the defendant would have a problem walking and texting at the same time during the videos you reviewed,
No.
out on a hot day?
No.
Okay. In your testimony, you said that he immediately walked away from the car after putting light bulbs in? And that's what we see on the video.
Correct.
Okay, and I hate to keep dealing with the semantics of this, but it's important to make sure we're clear. You testified, and today, or this week, and at the PC hearing, that at some point he turns his head, and it's above the frame or at the frame or something of that nature.
Correct.
Now, is that at the same point you were describing that if he'd looked, or where he was, that he would have had a clear view?
No.
Is that whole process of him opening the door, coming up, going to it before he gets his head up to the frame, is that the process you're talking about?
Coach, I'm gonna object to leading the kid, I mean,
Let's done.
Okay. What is the process you're talking about?
As he's walking up to the door.
So does he have, if he wants to look, does he have a clear unobstructed view up until the point he gets up there to the front, the roof of the car?
Yes.
Okay. Get you to clarify one thing, just so we're sure here from this hearing, talking about inside the frame, in the car, things like that. Let me get you to read the rest of it when you were asked about this specifically by the defense counsel on July 3rd, 2014,
well, if he's gonna read something, let me know exactly what.
page 90
Page 90 of what?
of the transcript of the probable cause hearing I was just talking about. Okay, page 90.
Well, hang on, I'm gonna object, it's, if he wants to read from it, that's fine, but I think it should be in the form of a probable question and answer.
Detective, can you read from this? Is it an accurate transcript? Is this put fully in context, your description of how you testified the video looked back in July 3rd of 2014?
I believe so.
Could you please read the question that the defense attorney asked you, that very detailed question?
So in that video, you didn't see him get into that car. You didn't see him look around in that car. You didn't see him grab anything out of the glove box. You didn't see him pick anything up off the floor. You didn't see him look in the back seat. You didn't see him look over the back seat. You didn't see him looking around, see if anybody was watching. You didn't see any of that on video, did you? And I answered, not at the car.
So you were asked correctly back then, did he ever go in the car, any of those things, and you agreed.
Correct.
Going back at lunch, he had the bag from Home Depot that he forgot to tell you about. Was there anything that you saw in that video that stopped him from opening up the back door to put him in there?
No.
Is there anything that stopped him from going to the passenger side to put the light bulbs in there
No.
and set them down? Was there anything that prohibited him from going to the back of the car where he's got that compartment to put light bulbs and store them?
No.
Heck, is there any problem, anything you know of, he would have had some problem getting dropped off at the door in the 90-degree temperatures and just walking into work with a bag?
No.
Have you seen him carry other stuff into the treehouse?
Yes.
Is he walking with a Chick-fil-A bag?
Yes.
A guitar?
Yes.
Detective, have you ever just thrown light bulbs you just bought?
No.
That's all I have.
All right, the first thing that I want to ask you about from all of that was, we'll call your attention to something specific Mr. Boren asked you about.
Yes, sir.
Messaging with Elizabeth Smith. That morning of the 18th, you testified that Ross had messaged Elizabeth Smith, "Can you come suck me today?" Right?
Yes, you can come suck me today.
Okay. And Mr. Boring asked you, well, there was no discussion about meeting up, was there?
No.
Why don't you read for the jury what her response was?
No, I'm in Hilton Head.
And what was his response?
Damn you, LOL.
So apparently she was out of town and they couldn't hook up that morning. Or that afternoon at lunch in his car, could they?
No.
I want to go back to, just real briefly, do you have a copy of the transcript with you? From
Which
July?
school?
July
Yes,
14th?
July 3rd,
That's right.
I did.
This was kind of skimmed over. Make sure we understand. Look at page 61. I want you to look at line 5 and 6. And specifically, you're being asked about that public service announcement video, right?
That's correct.
All right. And you were asked, how many times did he view it?
That's correct.
And your response was what?
He viewed it twice.
Okay. So your testimony under oath was that he viewed it twice.
Once again, it was cleared up. Do we know? No. But when you asked, it was accessed twice. So we don't know if he viewed it twice or not.
Yeah, but see, the thing is, you were under oath.
I understand that.
And you swore to tell the truth, the whole truth, and nothing but the truth, and you testified he viewed it twice. That's not true, is it?
I don't know,
Well, why'd you testify to it if you don't know?
because it was accessed twice.
Why did you testify that it was accessed twice?
I misspoke at the probable cause hearing. And it's possible that he viewed it twice.
Okay. So you're gonna stick with that it's possible he viewed it twice?
I'm gonna stick with that because at the time when I said that, it said 2 times. We did not know. It was accessed, viewed, looked at 2 times. It was 2 times, accessed.
But
And that's access is the word that we started using later on too. At that time, it said 2. I believed he viewed it 2 times. And then it was cleared up and we went on.
And by cleared up, you mean it was made clear that you were wrong about that testimony? He did not view it twice?
Well, it was cleared up that we're not aware, I was not aware at this time what access 2 times meant.
Okay. You are aware that there was a consultant brought in to look at this very issue, right?
Right.
In fact, in your notes, you discussed exactly what issues you wanted this consultant to look at, Jim Persinger.
Yes.
So this was something that was important. You wanted it looked into enough that you went to the trouble of getting an outside consultant, right?
True.
All right. But yesterday you testified that you have no idea what the results were of his evaluation.
That's also true.
Something that important, the lead detective, you weren't clued in or told or given a copy of his report or explained in any way what his results were?
No.
Do you know why it was kept from you?
Was this never brought up? I don't even know if a report's been made.
Your testimony today is that you do not know if there is a report that's been made,
I have not had a report given to me on this issue.
and you've never met with anybody to discuss it.
No.
Okay. All right, so Mr. Boring asked you about the parking lot video that we saw, so why don't we just take a look at it again? This is gonna be the video where puts the light bulb in the car and then walks away, and I want you to pay particular attention to when Ross is walking back to the treehouse, okay?
Before you go into this, how long do you anticipate this part of your recross?
I don't, Judge, I doubt I've